80th meeting of the Standing Committee on Public Safety and National Security. We have with us a familiar face, our Privacy Commissioner, and welcome again to the committee, sir, and I'll leave you to introduce your colleagues.
Merci, Monsieur le Président. Thank you, Chair and members of the committee. I'm here this morning with Patricia Cosim, who's our General Counsel, and Lara Ives, who's the Director General of Audit and Review. So thank you for the invitation to discuss Bill C-59. As you know, Bill C-59 introduces a wide range of measures intended to strengthen Canada's national security framework in a manner that safeguards the rights and freedoms of Canadians. On the whole, I find it represents a step in the right direction. But as other commentators have noted, its weakest part is the Security of Canada Information Sharing Act, or SCISA, which contains provisions related to information sharing and privacy. Professor Forsese, for instance, gave these sections a failing grade. I was therefore glad to hear Minister Goodale last week say that SCISA was probably a part most deserving of scrutiny. I hope your study will result in much-needed improvements to these rules. In previous parliamentary briefs, I highlighted the need for rigorous legal standards around the collection and sharing of personal information, effective oversight, and minimization of risks to the privacy of ordinary law-abiding Canadians, particularly through privacy-sensitive retention and destruction practices. Specifically, I indicated that the law should prescribe two things, essentially, two things that are useful to bear in mind. First, clear and reasonable standards for the sharing, collection, use, and retention of personal information, so substantive rules. And second, compliance with these standards should be subject to independent and effective review mechanisms. It is with this analysis in mind that I offer the following comments and recommendations. And while I will focus in my remarks on SCISA, this analysis, looking at two types of issues, is also relevant for other parts of Bill C-59, including parts 3 and 4. The full list of our recommendations is attached to this statement. Bill C-59 would create a new expert review body, the NSIRA, with broad jurisdiction to examine the activities of all departments and agencies involved in national security. Recently, Parliament also created through Bill C-22 a new National Security and Intelligence Committee of Parliamentarians. Both of these bodies will be able to share confidential information and generally cooperate so as to produce well-informed and comprehensive reviews that reflect considerations both by experts and by elected officials. These developments are most welcome, but they are, in my view, clearly insufficient. In my view, effective review of national security activities must include both parliamentary and expert review, and the latter must include both national security and privacy experts. Why privacy experts? Because the work of national security agencies depends in large part on personal information. It is what they call their, quote, lifeblood, unquote. The OPC is the federal center of expertise in privacy and personal data protection. Canadians are concerned that anti-terrorism efforts in government not unduly impede their privacy rights, and they expect my office to play a role in ensuring that balance. Bill C-59 is oddly silent on the role of my office. It does not amend the Privacy Act, so my existing authorities appear to be untouched, but the only body with explicit authority to play a role in relation to Part 5, the renamed SCIDA, or Security of Canada Information Disclosure Act, is the NSIRA, the National Security and Intelligence Review Agency. The FE Committee, in its study of SCISA, has already noted the ambiguity in the interplay between that Act and the Privacy Act, and it has called for amendments to clarify that the Privacy Act continues to apply to all personal information disclosed pursuant to SCISA. I have provided to your committee amendments that would confirm the application of the Privacy Act and the OPC's role, which I'm told the government wants to maintain. There is, however, no ambiguity on whether my office would be able, with Bill C-59, to share confidential information with the NSIRA and the new Committee of Parliamentarians. We would not have that authority And actually, we would be prohibited by existing provisions in the Privacy Act from sharing such information. This means that the comprehensive review process offered in Bill C-59 as a fundamental element to bring balance between security and respect for rights would stop short of the objective by leaving privacy experts out of integrated review. And I'm at a loss to understand why. If the fear is of duplication between our work and that of other review bodies, I would gladly explain through the question period how bringing the OPC firmly within the family of review bodies would not only bring required expertise, but would actually enhance efficiency and reduce overlaps. Lorsque le projet de loi C-51
When Bill C-51 enacted the Security of Canada Information Sharing Act, I indicated that among my concerns was the fact that the relevant standard for sharing was set too low and that there was an absence of clear data retention and record-keeping requirements and a lack of information sharing agreements with privacy impact assessments. The relevance test is too permissive because it casts too wide a net and creates undue risks for ordinary citizens who don't pose a threat to national security. The government seems to recognize that relevance standard does not sufficiently protect privacy because it's suggesting changes to Section 5 of SKIDA. In its response to the Ethics Committee, the government said, "The key issue regarding the threshold is the need to establish specific decision-making parameters for the disclosure of information that will protect individual privacy, but not cause undue delays in the information sharing process." I agree with that statement. The new proposed Section 5, particularly paragraph 5.1b, incorporates some aspects of a necessity threshold, but falls short of adopting what officials refer to as strict necessity. In order to adequately protect, or rather, this paragraph represents limited progress in order to adequately protect privacy rights. This limited progress is in increasing the threshold for disclosure, which would have to be accompanied by more complete information changes to the standard applicable to receiving institutions. Information sharing involves two parties, and to protect rights, rules are also required for receiving institutions. If relevance is not adequate for disclosing institutions, it is also inadequate, even more so, for receiving agencies, and the delay considerations that may apply to disclosure affect receiving departments very differently. These institutions, the receiving institutions, are, in my view, perfectly capable of applying the classic, internationally established necessity test and should be required to do so. We understand the government's intention is for receiving institutions to continue to be governed by the Privacy Act or their specific enabling legislation where applicable. The current Privacy Act threshold is relevance. As your committee recommended in its May 2017 report on Canada's national security framework, we also recommend that a dual threshold be adopted for information sharing, so Provision 5, with necessity and proportionality applying to receiving institutions. Even if one accepts that government sharing of information related to law-abiding citizens may lead to the identification of new threats to national security, once that information is analyzed and leads to the conclusion that someone is not a threat, that information should no longer be retained. Otherwise, national security agencies will be able to keep a profile on all of us. This is consistent with the conclusions of our review of CBSA's scenario-based targeting initiative, summarized in my latest report to Parliament, and it's one of the principles upheld by the European Court of Justice in the passenger name and record case decided in July 2017. In addition, if the threshold for collecting or receiving information is higher than the standard for disclosure, which is currently the case at least for CSIS, which is held to a necessity test for collection, then rules are required to ensure that information is that this information is discarded without delay, either when the collection test is not met, or if the receiving institution is of the view that the disclosure standard was not satisfied. In conclusion, my complete recommendations are at the end of this statement, and they include some I've made in the past and which I don't have time to explain in the time I have this morning. I also intend to write a fuller submission prior to the end of your study. In the meantime, I'd be happy to answer any questions you may have.
Darian, 7 minutes. Ms. DeBruzen, please.
Thank you for that, and I appreciate that you've provided us with recommendations specifically to it. Last night I was actually reviewing the Air India inquiry recommendations and trying to get a sense against that backdrop where 329 people were killed, just trying to put that as a backdrop of where their recommendations specifically pointed to problems with a lack of information sharing, and yet understanding that there are many concerns as to balancing privacy in that framework. So that's where I'm kind of coming to these set of questions, is trying to figure out where do we meet that balance. And you go quite a bit that way, talking about the required expertise that you can bring to help us with reaching that balance. And you touched upon it and said you might be able to give us more information about that in questions. So I'm going to open that to you. Where do you see your expertise coming in to help us reach that balance, and where would you have us slot that in? Because ultimately, we're going to have to be reviewing on a clause-by-clause basis this legislation. What would be the main recommendations that you've listed that you think can bring in that expertise?
So I start my analysis with what I think is the need to have good, clear, sufficiently high legal standards, including thresholds. So that's where the issue of relevance or contributing to the mandate or being necessary comes in. So substantive legal safeguards. And the second element, I think, of a well-balanced national security legislation requires a strong, independent, effective review. On the substantive legal safeguards side, I accept that that to apply the necessity test may pose problems for disclosing institutions, which is the main point that the government made in responding to ETHI, and which may have been a contributing factor to your committee when you suggested a dual threshold. So I accept that for disclosing institutions, a threshold lower than necessity helps disclosing institutions do a difficult task, yet having safeguards. But receiving institutions, essentially national security agencies, know very well what their mandate is, what they need to do their job, and there the necessity threshold, which is the international norm, should apply fully. So that's the main substantive recommendation that I'm making, which is again where this committee was at not long ago. Second substantive rule: if there is a difference between the threshold applicable to disclosing institutions and to receiving institutions, which would be the result of a dual threshold, it's easier for disclosing institutions to disclose. The threshold for receivers is higher. What to do for the gap if the receiving institution has received something that it is not necessary? Point one. Point two, if the receiving institution has received information about a law-abiding citizen, travelers is the best example, to identify in the mass of travelers the extremely few that may pose a threat to national security, there should be legal rules to require the receiving institution to get rid of the information, to destroy the information, to no longer retain the information if there's a gap between the two thresholds, or if in relation to a given individual, thus the analysis leads to the conclusion that the person is not a threat, and therefore that its information should not sit in the records of CSIS or the CSC or the intelligence apparatus. These are the substantive rules. In terms of effective review, it is clear that the creation of the new NSIRA is an important improvement, and the fact that it will be able to share information with the Committee of Parliamentarians creates something which is a good step in the right direction, in that you have integrated review applicable to all departments, not only 3 at the current time, and you have elected officials and experts who can talk to one another and reach a well-informed decision. What we think we can bring to the picture, and we're not in the picture, at least not completely, with C59, is that the lifeblood, la matière première, the main tool that national security agencies have to do their job is information, and that includes personal information. And we're the experts in how to deal with personal information in a way that respects privacy rights. So we're not saying that NSIRA would be without any knowledge of the relevant issues, but there's a core issue, there's an issue of core importance to the work of national security agencies, being privacy, where we're the experts, and we think we can add value to the rest of the architecture.
Thank you, and I only have 45 seconds. So I see that you have provided some recommendations as to effective review and oversight, but I was wondering if you might be able, when you're providing your written submissions later, to flesh that out as to how you see your interconnection with the NSIRA. Like where do you see us slotting that in your preferred situation?
In a few words, I would say that I have a broad mandate which goes well beyond national security, and I have limited resources. So if only for that reason, we cannot afford to be involved in national security activities as the NSIRA, which only task would be that.
Yeah.
So I think we need to be able to have discussions with NSIRA on where we fit best, where, in which cases would our expertise be of most value, on the basis that, for the most part, they would do the review. But there will be cases where we can add value because privacy will be particularly important.
All right, thank you.
And Monsieur Paulus, 7 minutes, s'il vous plaît.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. Good morning, Mr. Terrien. We can agree that September 11, 2001 was a turning point, or rather September 9, 2011, with regard to the terrorist threat. Last year I was at NORAD, and in Colorado Springs they told us that before September 9 they looked at outside threats to the U.S., and the Federal Aviation Agency looked after internal threats, but after that date everything changed, and the connection between the two agencies became permanent. With regard to C-51, 2 years ago, in March 2015, when you appeared before the committee, you said the transfer of information would affect 17 departments and agencies of the federal government, and for you, it was too many bodies sharing information. Do you still believe that information is shared too widely? I was a lawyer for the government during the period in question, and I was in charge of public and national security for 10 years after that. I'm very familiar with these issues. What I was saying in 2015 is that I agree with that information sharing is necessary to the effective work of national security agencies. When I was saying in 2015 that there were many agencies and departments involved, I wasn't saying that information should not be shared between a certain number of organizations, but I was just pointing out that there were gaps in the review process, which was only looking at 3 departments of the 17 organizations which were sharing information. I did not say that there should not be information sharing, and I did not say that 17 was too many. I was saying that if there are 17 informations that have information, they should all be reviewed independently. This morning, you said that Canadians are concerned that the government's anti-terrorist activities are affecting their private lives. Where do you get that from? On the one hand, you're saying Canadians are concerned, and do you have any examples? Well, actually, Canadians have concerns on both fronts. We receive communications from Canadians on a regular basis, and surveys have been taken over the years which show that Canadians are indeed afraid for their safety, for their security. That's clear. But other surveys also show that despite the fact that they are concerned with their safety, and that's normal, they expect the government and Parliament to nevertheless protect their privacy and their rights. And many surveys have shown this. Is it possible to see those surveys? Sure. A little farther, you talk about the relevance test, which is too lax. You're saying that it's possible to collect and keep information from citizens, ordinary citizens, but in this day and age, everyone is a potential suspect. So how do you distinguish an ordinary citizen who does not present a threat from a person who might present a threat? Well, I'm aware of that distinction, and this is why I said that the widespread collection of information to identify threats has to be reasonable. But once an analysis has been completed and once a determination made that most of the people whose personal information was collected, well, that information has to be destroyed because national security agencies cannot indefinitely retain information on people who have been deemed not to be a threat. So it's a wide funnel at the top which targets many people, and many of those people are not threats. Once that determination is made, that's fine. But once that determination has been made, that most people do not represent a threat, the information collected on them should be destroyed.
Closer to 2.
Donc, par rapport à C-51.
So with regard to C-51, so you were very critical of C-51. You still have reservations with regard to C-59. You're still not completely satisfied. What you're saying is that the collection of personal information is fine, but it's the back end which is a problem in C-59. What to do with all of that information? What do you mean by finalité? Do you mean the purpose? Are you saying... I'm saying that it's fine to collect information to assess a threat. But once that information has been analyzed, and if the determination has been made that most of the people do not pose a threat, the information collected on them has to be destroyed by all of the departments, agencies, and organizations, has to be destroyed, and there has to be clear wording to that effect. When C-51 was introduced, some people said that their online information could be collected and that there was too much intrusion into the private lives of agencies. In your opinion, is that still a problem in Canada? Do you believe that today our agencies are too involved in the private lives of Canadians? Do you believe that private online information is at risk, for instance? We reviewed the enforcement on the information on SCISA, the Security of Canada Information Sharing Act. We did not find undue intrusion. We have a problem with legal standards. CERC is continually looking into those issues. We have other agencies which are also looking into those issues. We have only conducted one review of the application of the Security of Canada Information Disclosure Act. We have no problems with the Act. It is legal standards which are a problem for us. Thank you, Mr. Dubé. Thank you, Mr. Chairman. Mr. Terrien, thank you to you and your team for being here this morning. I have a question on CBSA, the Canada Border Services Agency. Do you believe that there should be an organization, an agency which oversees CBSA? And do you think that C59 should create an agency to overview CBSA and other national security agencies? As far as I know, CBSA is included in the oversight mandate of the agency, the National Security and Intelligence Review Agency. As far as I know, this agency has the mandate to oversee the agency you mentioned and others. Now, as opposed to other agencies, the day-to-day operations of the NSI or rather, the day-to-day operations of CBSA is different from that of other security agencies. Is there a danger that the agency only look at national security issues and not the everyday operations of CBSA and Canadians crossing the border? Yes. When we reviewed the various issues under SCISA, we conducted an annual review which included looking at CBSA and its activities, and we looked at whether they enforce certain scenarios CBSA engages in to screen travelers coming into Canada and which might pose a threat to our country. So we did review this particular program as applied by CBSA. This is a national security issue, and CBSA, of course, also looks at other types of crime. Since CSIS collects information, do you believe that the safeguards contained in C59 are adequate? Well, data sets is defined very widely, and it could be a problem if we did not have stricter measures to control activities and legal standards. We need good legal standards to frame the information collection process. The standard is Judge Noel, which had said that certain agencies had retained information on people who were not a threat. Judge Noel also said that information, so the judge said, I've listened to the evidence and I've determined, or rather the agencies said that the information could potentially be useful. I believe that the value of information has to be more clearly defined. There are different, but there have to be different criteria to ensure that personal information is not retained indefinitely. I believe the 90-day threshold is appropriate. and CSIS should collect and retain information based on the necessity criteria, and this would also apply to the sharing of information. I believe that the provisions are inadequate, or rather would be adequate if the criteria was necessity. I've been saying this for 2 years now. I would ask you to apply the necessity standard to SCISA when it comes to the sharing of information. I would like to stay with data sets. The definition of data sets, again, it's very wide. On Tuesday, we heard from certain witnesses, and these witnesses said that it's good that the definition be wide because we cannot constantly be playing catch-up. Technology is evolving so quickly. However, on the flip side, is this a concern? In other words, in 5 or 10 years, we don't know how information will be collected, what information will be collected by various agencies. Yes, I think there is a risk, and I think it is managed fairly well. The definition could be tightened, but perhaps national security agencies, including CSIS, would be unable to collect information or intelligence which it needs to do its work. Yes, there is a risk. How to manage it? By having independent control and effective mechanisms. I see in the part which in C59, which covers CSIS, there are a certain number of filters, control mechanisms by independent agencies, agencies independent of the government, of CSIS. There are thresholds, and the necessity criteria is applied, and I believe those safeguards are good. In Part 3, it says that in the course of its operations, CSEC, which addresses foreign threats, do you nevertheless believe that too many powers are given to CSEC when it comes to online information? Yes, CSEC has the right to collect a great deal of information, including data sets. Again, we're looking at a funnel here. A lot of information can be collected at the front, but under Section 35, privacy information must be protected, and there is a clear definition further in the bill at Sections 35, 44, and the following ones. Not only CSEC not only has the obligation to protect the privacy of Canadians, but there's a very specific definition which leads us to ask the following question. Before a decision is made to keep and use the intelligence, it has to meet the necessity criteria, and it must be part of the mandate of CSEC. And again, the necessity test is here. It applies to necessity means information which is relevant to CSEC's mandate.
Merci. C'est toujours un plaisir de vous retrouver. Votre expertise est...
Thank you. It's a pleasure to have you here. Your expertise has been acknowledged, and we appreciate your very specific answers, and we are happy to advance our study. We're at the most important part of our study because we are considering amendments to the Act. Quick first question. Is there anything in the Act that governs you which prevents you from participating in these activities? My staff has a top security clearance.
L'inquiétude, elle est là, c'est clair, elle est indéniable, et c'est normal.
Now, there is no doubt that there is a threat. It is what it is. But correct me if I'm wrong, we're beginning to feel that people are acknowledging the threat, the reality of the threat. They see what's happening around the world, And perhaps they're more open to compromise because at the end of the day, we have to balance security and rights. And this is an ongoing balancing act. Do you also have the impression that Canadians are beginning to question the protection of their privacy rights and perhaps the necessity of sharing their information more widely?
Dans le temps, puis pour prendre des circonstances évidentes, suite aux révélations d'Edward Snowden, évidemment, il y a eu un pic dans l'expression d'inquiétude, de préoccupation du public pour s'assurer que les droits, y compris la vie privée, soient respectés. Puis suite à un événement terroriste, généralement, la balance va aller de l'autre côté. Alors, je pense qu'il faut... Moi, ce que je vous suggère, c'est...
Balance swings the other way after a terrorist event. So we have to consider that the public is concerned by both questions, physical security and the respect for rights. And it can fluctuate with time. I think our work, your work, the executive's work, is to put in place laws or statutes that bring a balance over time without taking into account revelations or terrorist attacks, and takes this over time. It's in the long term, and of course there has to be reviews, and some great suggestions have been made in the bill, but I still think that we have a role to play. We want to make sure that those rules are applied correctly every day by the agencies.
The debate on privacy versus security is ongoing. There's no doubt we must protect our privacy rights. For people listening to us, everything we're talking about is still theoretical, so it might be a good idea for you to give us a couple of very concrete examples of privacy rights and a breach to privacy rights in the interest of protecting national security. Perhaps just having the name of someone is not enough. I'm flying to Europe in 2 weeks. My flight ticket. Is this included in what is called private information? Or would you be collecting even more personal information? Can you give us some specific examples of what personal information is, which may be useful in countering threats? Travelers, that's a great example. Most of us travel, so it is normal for different countries to control the information of passengers in the interest of national security. There are millions of travelers, but just a tiny, tiny fraction might pose a threat. But in the case of CSIS, for instance, it must have access to the names of these travelers to make sure nobody is threatening our national security. But there is no specific rule today which says that CSIS must destroy information when it has decided that 99% of people do not pose a threat. Under this bill, will that not be happening, though? Will information not be destroyed under C-59? Well, under Part 4, which addresses data sets, that's what it says. The federal court must determine whether data sets should be destroyed after 90 days. That's exactly the type of measure I'm applying. And this also applies to the sharing of information. If that applies to data sets, it should also apply to personal information. So there are two issues here. One, there's objective information, which may or may not have value. this information can be shared. If two or more agencies are involved, we have to apply the necessity test. Is this, does this apply to relevance? Somebody might say this information is necessary, or rather, different agencies might assess information differently. And this is where I have a problem, because which threshold applies? Well, it's a gray area, and this is especially the case for the collecting agency. The collecting agency might not necessarily agree with the assessment of the intelligence of the potentially receiving agency. New Section 5 is not perfect, but it's fine. If it is applied, the sharing information, for instance, the Department of Agriculture, which does not have many security experts, this ministry, this department might feel it can share certain information. Now, when CSIS receives the information, it must analyze the information, and CSIS knows exactly what it needs, what the necessity test is. CSIS would know, nope, I've gotten too much information, and if there is too much information which is not relevant, CSIS must be obliged under law to destroy that information, again, if it is not necessary to its work.
Thank you, Mr. Chair, and thank you, Commissioner, and your team for being here. You had indicated in your recommendations, and thank you for providing some additions, specifically in recommendation number A, with removing ambiguity, I suppose, with respect to the role of the Privacy Commissioner, as well as that you should be among the review bodies having the legal authority and flexibility to share confidential information. As you can read there, I'm just curious, besides yourself and your background, does your office have the expertise to understand the ramifications and overall impacts of national security and the intel sharing?
We have, I'll say, about 10 employees who, one, have the security clearance and who review these issues from time to time, and who, yes, have the knowledge and expertise to know the context. I would go on just briefly to give the other side of the coin. If we're not involved, it would mean that the expertise that we have garnered through our work generally vis-a-vis all departments would not benefit national security agencies. So that's something to bear in mind.
Okay, thank you. Would you see a change in your mandate, the mandate of your organization, with the passage of C-59? And if so, would you be requiring to allocate more resources to manage those changes?
If my recommendations are adopted, no.
Yeah.
No.
No? Okay.
We don't need an army of people. We have a broad mandate. We supervise the private sector as well. I don't envisage that we would need more resources.
Okay. Now, would you see the National Security and Intelligence Review Committee as a positive addition?
Yes.
To standardized practices without allocating resources from protecting Canadians to the compliance and red tape practices?
I think all review bodies should be sufficiently resourced, which does not mean necessarily a huge infusion of resources, but they should be able to do their job properly. Whether something is red tape or necessary review is, I guess, in the eye of the beholder. At this point, given the level of resources that CERC and the CSC Commissioner and my limited resources have, I would not talk about red tape. We're talking about, at the most, 20 people. This is not red tape. This is necessary review, and there needs to be sufficient resources to do that job adequately.
Okay, thank you. 3 inquiries, Air India, ARAR, and the O'Connor decision, have identified sharing information and communicating threats is critical to having an effective national security team, and I think you've indicated certainly that you agree with that. With this new National Security Intelligence Review Agency, can some of the overall issues you found with procedure and reporting be fixed?
With procedure reporting?
With procedure and reporting, can those things be shored up with this new review agency?
Absolutely. NSIRA is a very important step forward, in part because its jurisdiction encompasses all departments and agencies involved in national security, which is a flaw of the current system. What I'm recommending is that our expertise be added to this mix so that the sum total of expert review and parliamentary review be able to give Canadians the assurance that both their security and their rights are protected.
So, would you characterize the proactive collection or centralized intelligence as a threat to privacy?
I'm not sure what you mean by proactive and centralized. The fact, I answered Mr. Paulus to say that I agree that the collection of information, including of some who are not a threat, can be useful to actually identify threats. So if that's what we mean by proactive, yes, I agree with that, so long as there are safeguards to ensure that those who are not threats are not, that their privacy is not at risk.
Good. Thank you, Mr. Mines. Mr. Spiegelman, 5 minutes.
Mr. Chair, thank you very much. Mr. Therrien, thank you for being here with your staff and for your expertise and testimony. I wonder if I could build briefly on the question that my colleague Mr. Picard asked you in the form of an example to make it concrete for the committee, but also for Canadians who are listening now or are reviewing your testimony in the future. Could you give us an example of a case from the area of security that would highlight how the application of relevance, necessity, and proportionality would unfold? Perhaps an example that both meets and then in an extrapolation exceeds the threshold of each of these, so that there's a better understanding on the part of the Canadian public what analysis is actually taking place here.
The best example would be, again, that of travelers. So the information about travelers, many of whom are not a risk to national security, may be relevant, may contribute to the mandate of the receiving agency, to use the words of the new Section 5, because in the mass of travelers might be some who are a threat. So to have information on a more permissive relevancy or contribution standard may be acceptable at the front end. But when that information is then received, analyzed by the National Security Agency, and the agency determines that the individual is not a threat, on what basis should the information be used and, moreover, retained by the agency? The retention of information about 99.9% of the travelers who are not a threat is not necessary to their work, to their mandate. I would go back to, I think, looking at C-59 as a whole with all of its parts, I'm struck by the fact that parts 3 and 4 have essentially the standards. I understand that relevance and necessity are somewhat esoteric notions. I understand that. But in parts 3 and 4, the government and you as parliamentarians are seized with a bill which actually recognizes that there's a need for the higher necessity threshold in some circumstances. The CSIS and the CSE will not be able to actually use and exploit the personal information of individuals unless it meets a necessity test. If it's good for parts 3 and 4, I'm saying it should be good for part 5.
Okay. In your view, is there a risk of the collection of irrelevant information at the outset? You're advocating for a broad funnel, the way I understand it, at the beginning. What kind of information might be irrelevant, and is there a risk to actually collect irrelevant information?
If the threshold for the receiving institution is higher, is necessity, yes, it will receive irrelevant information, but only for a fleeting period, and that may be a price to pay for the fact that in that
Right.
large basket of information, some may be relevant.
Yep. And so we shouldn't really be concerned with the quality of the irrelevant information. There's no categorical concern about
I wouldn't say we should not be
collecting what people
concerned
eat
at
for
all,
breakfast
but I see safeguards, including reliability of the information in the bill, which are useful. But I'm less concerned at the front end, the disclosing end, than I am at the receiving end.
Okay, thank you very much for that. My second question goes into the area of youth and the criminal justice system. As you know, in counterterrorism work or terrorism generally, youth are often the target for radicalization efforts by such entities as Al-Shabaab or Abu Sayyaf or ISIS. And youth are vulnerable in many respects with respect to data as well. Section 159 of the bill brings the Youth Criminal Justice Act into play on the criminal justice side of things. What concerns, if any, do you have that are specific to Canadian youth from the privacy side?
I'll confess that we haven't paid much attention to this, but we will, and we will address that question in our submission, our ultimate submission.
I'd be grateful. Thanks very much. Do
You
I
have 30 seconds.
Are you in a position to comment whether there will be judicial review of the work of or decisions of the Intelligence Commissioner? Judicial review being an important component of accountability and ultimately privacy as well. Would he or she be subject to judicial review in your assessment?
I haven't thought this through in detail, but the Intelligence Commissioner is an interesting new creation. It is more of an oversight body. It reviews matters before the fact as opposed to after the fact review. So it's a bit novel and in a different position than, say, the current CERC, which is clearly subject to judicial review. So I would say probably yes.
If you could add your thoughts into your written submissions, I think that would be helpful to the committee as well.
Okay.
Yeah,
Thank you,
thank
Mr.
you,
Chair.
Mr. Spengelman. Mr. McKenzie, 5 minutes, please.
Thank you, Chair, and thank you to the Commissioner and your panel for being here today. I'm intrigued by your comments about 90 days for the destruction. How broad is that across agencies when they look at their information and within 90 days they don't see any value? Is that what you would suggest, is that the destruction period would occur?
Well, the 90-day period in Bill C-59 applies to the specific situation of the collection of data sets by CSIS. So in a model where it's conceivable that more information may be required at the front end, but an exercise is required to funnel this to fewer information at some point, it's important that that period of analysis not be too long, but give the time to security agencies to do the analysis that they need to do. 90 days strikes me as a very reasonable period. Should it be 90 days throughout, regardless of whether it's CSIS, CSC, or others, we would have to look at it, but 90 days is a good rule of thumb.
But from a practical operative view, that may be a short period of time, and I only look back to the more recent situation in New York City with the motor vehicle running down the people on that street. And the Brits went back and looked at their records and determined that they had missed something in a telephone call that would have been helpful. And I don't know whether it was 90 days or more, but it just seems that frequently it's the necessity to go back maybe a little bit longer and then make the connections not only directly to that, but to other events.
Absolutely. So there's no magical solution here. It's a question of balancing the value of the information and how long agencies should have to analyze it. But obviously the delay cannot be so long as to result in the creation of profiles or dossiers on all of us forever. I'll note for the CSIS provision in Part 4 that after 90 days the court determines not necessity but whether the information can be useful. So it's a threshold. We're not yet at the necessity stage. It's when this bank of information is then queried by officer that the necessity threshold applies. So I think there's room in the regime for CSIS for information that may not be clearly necessary at that point to be kept, but it can be useful, but will only be queried by CSIS officers at the back end on a necessity threshold.
Okay, appreciate that. In looking at this legislation as you have, how would you compare it, if you have, with, say, our allies in the same business as we are here with counterintelligence and terrorism, particularly, I guess, with the Five Eyes?
I think on the whole, this legislation would allow Canada to catch up to Five Eyes, particularly this plus C-22 on the Committee of Parliamentarians would allow some catching up to do, and perhaps getting near the front of the pack.
Okay, and I just like to go back just very briefly on the destruction of at 90 days. I think you would appreciate, as most would, that once the destruction has occurred, it's very difficult then to reassemble the information. And how do we balance that for our security agencies?
Absolutely. That's why I say the standard applied by the federal court at that 90-day stage is not necessity. It's perhaps somebody can help me with the standard, but it's less. It's essentially, would it be useful for a national security investigation? So that's a way to ensure that potentially useful information is not destroyed too early.
Right, thank you.
Mr. Franciscatos, please.
Thank you very much, Chair, and thank you for being here today, Mr. Therrien. Question about the connection between speech and privacy. I think you would agree that free speech and the right to it and privacy enjoy a very intimate connection and an interdependent connection indeed. C-59 would replace one of the most controversial features of C-51, that is the advocating of terrorism offenses in general, with a more traditional offense, that of counseling specific terrorism offenses. We heard just the other day from Professor Stephanie Carvin, who in a piece for the Globe and Mail has written that, quote, "This better respects freedom of expression while still recognizing that much speech, including terrorist recruitment and instruction, is a reasonable target for criminalization." Can you comment on this change in C-59 and what you make of it from a privacy perspective?
I would agree. I don't have much to add to the analysis of Professor Carvin. To be frank, I focused more on SCISA because that's the weakest part. But I've noted, of course, the provision you're referring to, and I think that is an improvement in terms of striking the right balance between here freedom of speech, privacy, and ensuring the security of Canadians.
Thank you very much. Where in your comments, and you've followed up on that, the point about privacy experts being involved with the NSIRA, can you go into that a little further? You know, are we talking about an oversight role to ensure that the Privacy Act's provisions are being followed? You've talked about examples specifically relating to travelers, but are there other examples that you could mention and give us an idea of how officials focusing on privacy could have a role in such a body?
Sure. So yes, the application of the Privacy Act would be part of this, and the lessons learned in the application of the Privacy Act otherwise in government to national security agencies. I think it's important that national security agencies be covered by specific rules, yes, as in C-59, but also the legal regime of the Privacy Act, because these are emanations of the state, and as all emanations of the state, they should be covered to the general rules applicable through the Privacy Act. An example of where we might add value in about 2 years ago, we reviewed an incident involving the unfortunate but unlawful disclosure of metadata by the CSC to Five Eyes. And we played a very specific role. We did not look at all of the situation, but we looked at sufficient parts of that situation to look at the importance of metadata to privacy. And we were able to look at the deficiencies, make recommendations on how to improve things, and play a public education role to make sure that the public was informed of the importance of metadata for privacy protection. So that's something that we added.
Thank you very much. A final question. In your overview of C-51, you wrote in the Globe and Mail shortly after the bill was released, you said that, quote, in a country governed by the rule of law, it should not be left for national security and other government agencies to determine the limits of their own powers. On balance, are you satisfied that Bill C-59 has addressed this concern?
On balance, C-59 makes important improvements, but the recommendations that I'm making, particularly on the necessity threshold and legal safeguards for retention or destruction, are necessary, I think, to achieve the right balance.
Thank you very much.
Mr. Radskatos, and on behalf of the committee, Mr. Therrien, I want to thank you and your colleagues for your presentation, and very thorough presentation, and just remind you that there was some undertaking to Mr. Paulus concerning the survey, to which we'll look forward to receiving. So with that, we will suspend, and I'd encourage everyone to be very brief, because otherwise we lose time. So the meeting suspended. Call the meeting back to order. We have as our next set of witnesses the Canadian Civil Liberties Association, and as individuals Christian Leipert and Haley McNorton. Unless you have any other way of ordering this, I'm just simply going to go in the order of the Canadian Civil Liberties first, Christian Leipert second, and Haley McNorton third. So is the Civil Liberties ready to go?
Sorry, Mr. Chair. Kara Zwiebel has just stepped out. We would ask that someone else go first. She'll be here in just a moment.
Okay,
Thank you.
Christian Leeper, please. Thank you.
So we'll do a two-part here. I'll sort of set the scene, and then Ms. McNorton is going to explain specific recommendations that we have. I have copies of these, and I've also submitted them to the committee for translation, but I'm happy to circulate the documents.
So we should have you go first, Ms. McNorton second, and then we'll go back to civil liberties.
Correct.
Okay, good. Thank you.
So I think we need to ask ourselves why we are here. And I think one of the challenges that we've had is we hear a lot of tactics, but we don't hear a lot of what's the strategy and what's the ultimate rationale behind this. And the rationale is that as Canadians, we've long lived in an environment where we believe that we have been safe by virtue of where we are in the world, which is very far away from all the troubles in the world. And I would submit that this is no longer the case, that the fundamental conditions have changed, that the security threats and vectors are much broader and much deeper than they have ever been. If you think about hypersonic maneuverable cruise missiles, you think about intercontinental ballistic missiles, you think about the cyberspace, you think about violent extremism, terrorism, ideology, but you also think about matters such as the globalization of organized crime. And so these are all things that we can't just keep away from our borders. They affect us here now, and they affect us every day. So the security environment has fundamentally changed, that the premise of we're somehow safe because we're far away from the troubles in the world simply no longer applies. We've also, of course, seen these threats specifically associated with certain entities. This is often what's referred to as the 4+1 issue. So 4 countries, China, Russia, North Korea, and Iran, and the +1 is transnational terrorism. In Canada, we don't have a systematic human foreign intelligence service, so we rely disproportionately on our signals intelligence service to provide us the foreign intelligence that we need in order to get domain awareness. We also have the benefit of being part of the Five Eyes community, and this membership should not be taken lightly. There is an international security hierarchy in the world. If you think about this as a pyramid, the United States at the top and the Five Eyes community below that. And that means we need to be able to continue to be effective contributors to that community if we want to benefit from that community. The benefit from that community has precisely been that we have been able effectively to underinvest relative to most of our allies in defense, in security, in intelligence, because we have this force multiplier capability of domain awareness and overcoming the fallacy of composition that we wouldn't otherwise have. And so we need to balance here our obligations and the benefits to that community with the constraints that we impose on our own community. We've also seen a fundamental change in the intelligence business as a result of two events, if you want. One is the advent of the internet and of large data. And it means not just that the bad guys have been exploiting those systematically. And I would submit that in Canada, we have been a little bit too easy on the bad guys who exploit the internet and data, and too hard and make life a little bit too difficult for the people who are actually trying to disrupt, rein in, detect, and defend us against these nefarious entities. So we need to strike a balance between, if you want, the good guys and the bad guys. And of course, the advent of 9/11 has fundamentally changed the intelligence community and also the expectations that the public has of the state in terms of keeping them safe and secure. And more than ever before, in light of the threats that I've outlined, we are relying on intelligence to help us anticipate the security and safety challenges for Canada and to be able to mitigate those challenges effectively. My fourth and final submission on this point is that as a result of the Snowden revelations, much of the public has some skepticism about how the community operates. We are not here because there's in any way some large-scale violation by the professionalism or the capabilities in which the community does its job. We have the odd issue that comes up. Usually those issues are first identified by the community itself and then brought to the appropriate offices. So we have a professional community. But we have the public that is skeptical, and so I think the primary purpose of review here is to reassure the public that in a rule of law society and in a constitutional society, everything is indeed on the up and up. The other problem is we have a massive public misunderstanding of what the community does, why it does it, and how it operates. And that's as a result of the media, because where we see the community operate is largely on television, where we have shows about law enforcement, intelligence, terrorism, whatnot. And if you watch those shows, the systematic violations of the rule of law and of constitutionalism, it makes for great television, but it is simply not how the community operates. But this is what most Canadians and much of the public thinks is happening, reinforced by some of the way that the revelations by Edward Snowden have been interpreted and misinterpreted in much of the public discourse. I would also say we need to be careful then in Canada with the security culture that we've created. On the Five Eyes community, we have by far the most restrictive privacy regime. This is a choice that we have made as Canadians. But what we're doing here is we need to balance this with, so other countries that have very more rigorous parliamentary and other review mechanisms that Canada has, have also given their community more latitude in terms of how it can act, what it can do, and how it can do it. And so in Canada, I'm a little concerned that on the one hand, we're imposing considerable constraints on the ability of the community to be agile and flexible to continue to reassure the safety and security of Canadians, while at the same time imposing this very strict review regime, which, yes, is necessary to reassure the public, but we need to make sure we strike an effective balance here. And so I hear lots of people constantly talk about privacy, as if review was only about privacy, which of course is nonsense. There's review, there's oversight, yes, there's compliance review, but review is also about efficacy, so are Canadians actually getting what they pay for from the community? Currently, nobody is actually really able to ask that questions, and we will now, as a result of these mechanisms, have the ability to ask those questions. And effectively, these committees will also be peer review for the community. Are they doing the best job they possibly can with the best methods and the best approaches that are available to them? So this discussion that is simply about privacy, to me, misconstrues the broader benefits and payoffs of a more robust review regime by parliamentarians and by the now revised community of review bodies that will have a broader remit overall. So I'll close on 6 questions that we need to ask ourselves when we try to introduce this type of legislation. What are the methods that should be used to hold the intelligence and security agencies to account? What ISAs, what intelligence and security agencies should fall in the remit of those accountability bodies? Who is staffing those accountability bodies? What relationship does the accountability body have with the political executive? To what information does the accountability body have access? And is there more than one accountability body? How do they coordinate and how do they prevent duplication? And this dovetails now with Ms. McNorton's recommendations that follow directly from some of these issues that we have laid out here that people need to think about when we implement such legislation.
You have about 2 minutes left.
So to enhance intelligence accountability, we have suggested 5 recommendations. The first, Bill C-59 does not describe if and how NSERA, which is the National Security and Intelligence Review Agency, will support the National Security and Intelligence Committee of Parliamentarians. In the existing system, the Committee of Parliamentarians could apply to OCSEC, the Office of the CSE Commissioner, or the Security Intelligence Review Committee, or the Civilian Review and Complaints Commission if they needed additional assistance. However, if Bill C-59 is passed, they will only be applied to NSERA or the CRCC. In regards to this recommendation, we consider how much support NSERA will give the Committee of Parliamentarians and what kind of support they will give the Committee of Parliamentarians. The second suggestion is that the Civilian Review and Complaints Commission should retain its ability to review issues and investigate complaints related to national security. This is related, the existing legislation giving NSERA the ability to review matters related to national security issues goes against the recommendations from the O'Connor Commission. Also, in the end, it would give CRCC undue influence over what NSERA reviews in regards to national security, because NSERA will remain the principal point of contact for the complaints and reviews, which it would then refer to NSERA. The third recommendation, NSERA should have the ability to conduct joint investigations with provincial police and complaint bodies. The CRCC has this power as well. Basically, a lot of the federal intelligence and security agencies in their work, they work with provincial police bodies, so that is also a consideration. NSERA should develop and establish standards for intelligence accountability. And lastly, NSERA should take reasonable steps to cooperate with the Committee of Parliamentarians to avoid unnecessary duplication of work in relation to the fulfillment of their respective mandates.
Thank you very much. And BC Civil Liberties, I assume you're ready.
Yes, my apologies to the committee for coming in late. Thank you, Mr. Chair and members of the committee. The Canadian Civil Liberties Association appreciates the opportunity to make submissions with respect to Bill C-59. CCLA was a vocal critic of the Anti-Terrorism Act passed in the last session of Parliament and initiated a constitutional challenge to a number of aspects of that law, which remains in abeyance pending consideration of Bill C-59. While this new bill has partially addressed some of Bill C-51's constitutional deficits, it has certainly not resolved all of them. The bill also grants our national security agencies a number of extraordinary new powers that have not been adequately justified and that do give rise to very real civil liberties concerns. The government has framed this bill as being about both protecting national security and rights. CCLA supports both of these goals, and our comments and recommendations are made in that spirit. We will begin by identifying the positive changes C-59 makes to former Bill C-51, outline the issues that remain unaddressed, and finally set out the new problems created by C-59. Since we certainly can't cover everything in 10 minutes, we'll also be filing a more detailed written submission. Beginning with the items that C-59 has improved, we are reassured by the government's amendments to the terrorist speech offences. Without these amendments, the provisions violate Sections 2 and 7 of the Charter and may also undermine community-based de-radicalization efforts. While the amended offence is arguably unnecessary, given the large number of pre-existing terrorism offences in the criminal code, counselling offences are a known quantity in the criminal law and follow a clear legal framework. However, the language of terrorism offence in the amendment would be better changed to terrorist activity, which is a defined term in the code. On information sharing, Bill C-59 adds new proportionality and reporting requirements, which is a distinct improvement over the largely unaccountable system introduced in Bill C-51. However, the definition of threats to the security of Canada that triggers information disclosure remains unduly broad and circular. It is not clear why this definition is so much broader than the one included in the CSIS Act, and we remain concerned that constitutionally protected acts of advocacy, protest, dissent, or artistic expression, particularly by environmental and Indigenous activists, will continue to be swept up in the process. One of the most controversial aspects of Bill C-51 was the threat reduction powers granted to CSIS and the accompanying warrant provisions, which appeared to allow for judicially sanctioned charter breaches. We do not doubt that there are times when CSIS may see an opportunity to take action to reduce the threat to the security of Canada. What is unclear is why better communication and cooperation between CSIS, the RCMP, and other law enforcement bodies is incapable of achieving this goal. This is a very significant shift in mandate that appears to ignore the historical reasons for separating law enforcement and intelligence in the first place, and there has been no convincing case made out for why this shift is necessary. Moreover, the legal framework for the exercise of these powers established in Bill C-51 was deeply problematic and clearly unconstitutional in our view. The scheme as modified by Bill C-59 is an improvement. It establishes clearer contours around what actions are permitted and what is prohibited, and the warrant scheme appears to be intended to ensure that the charter rights of individuals are respected. If CSIS is to continue to have these powers, there are a number of ways in which we believe the scheme should be improved. First, the requirement for CSIS to consult with other federal departments or agencies to see if they can reduce the threat should be amended to clarify that if a law enforcement body is better placed to do so, CSIS should not pursue threat reduction. Second, the list of measures set out in proposed Section 21.1, subsection 1.1, only require a warrant where CSIS determines that they may violate the law or limit a charter right. A warrant should be required in any case where these measures will be pursued by CSIS. It is vital that the determination of whether a law is being violated or a charter right limited is not left solely to CSIS. Finally, the new National Security and Intelligence Review Agency should be required to report on the number of warrants issued under Section 21.1 and the number of requests that were refused. CERC does so now, and reducing reporting requirements is not consistent with C-59's stated goal of enhancing accountability. Some of the most problematic aspects of C-51 received only cosmetic improvement or none at all. As this committee is aware, the Passenger Protect program continues to raise serious constitutional problems. The process by which individuals are placed on the list remains opaque, and proposed redress mechanisms are inadequate. Bill C-59 also fails to correct the flawed appeals procedure, which parallels the system in place for security certificates prior to the Supreme Court's Charkaoui decision in 2007. While the no-fly list is undoubtedly different than being named in a security certificate, both have the ability to substantially interfere with the constitutionally protected rights and liberties of an individual and to seriously impact their lives and families. The current process allows the use of hearsay and secret evidence without access to a special advocate able to test that evidence or to represent the interests of the listed person. This committee recognized these profound issues in May when it recommended the use of special advocates in no-fly list proceedings, among other safeguards, and yet Bill C-59 does not address these concerns. It should do so by adopting this committee's initial recommendation. We would note that the terrorist entities list raised similar issues.
Mr. Chair, another deeply problematic aspect of Bill C-51 that has not been touched in this bill are changes to the Immigration and Refugee Protection Act, which undid important protections for named persons in security certificate proceedings. C-51 limited the requirement for disclosure of relevant information to special advocates and introduced a series of procedural barriers which further disadvantaged the rights of the named person. In our legal challenge, CCLA has argued that these amendments are an unconstitutional violation of the Section 7 guarantee to a hearing before an independent and impartial tribunal. And our Supreme Court has affirmed that the individual named in a security certificate must be given an opportunity to know the case to meet and an opportunity to meet that case, unquote. An impossible exercise in the absence of a coherent legal framework for full disclosure. This committee recognized as much in May 2017 when it recommended amending IRPA in order to give special advocates full access to complete security certificate files. We urge that C-59 be amended to correct this issue. We move now to the new elements of the national security landscape that C-59 has introduced. Our written submission will address a much wider range of issues in relation to the CSE Act, but we would like to highlight two parts today. First, the proposed active and defensive cyber operations aspects of the CSE's mandate essentially allow the establishment to engage in secret and largely unconstrained state-sponsored hacking and disruption. The limitation of not directing these activities at Canadian infrastructure is clearly inadequate, given the inherently interconnected nature of the digital ecosystem. Such activities are also bound to impact privacy, expression, and security interests of Canadians and persons in Canada, and may threaten the integrity of communications tools such as encryption and anonymity software that are vital for the protection of human rights in the digital age. In the case of CSIS's disruption powers, which are in some ways analogous to these new aspects of CSE's mandate, the government has set out a complex framework for prior judicial authorization and a longer list of prohibited activities. While we do not concede the adequacy of that framework, it is notable that in contrast, CSE's cyber operations activities involve no meaningful privacy protections, require only secret ministerial authorization, and involve only after-the-fact review. Second, while the majority of CSE's activities cannot be directed at Canadians or persons in Canada, this is an inadequate safeguard against CSE's overreach in the face of unselected bulk collection. Bill C-59 exacerbates this privacy risk by creating a series of exceptions for the collection of Canadian data, including one which allows the acquisition, use, analysis, retention, and disclosure so long as it is publicly available. This definition is so broadly defined that it plausibly includes information in which individuals have a strong privacy interest and potentially allows for the collection of private data obtained by hacks, leaks, or other illicit means. Furthermore, it may encourage the creation of gray markets for data which would otherwise have never been available to government, a client with deep pockets. The government has failed to demonstrate why this exception is worded as necessary or proportionate, nor what risk is meant to mitigate in the first place. Yeah?
Appreciate the time is the enemy here, but you're speaking so quickly that the interpreters are having difficulty keeping up. So if we could just slow it down just a sec.
Absolutely. Thanks.
Okay. Sorry about that.
Thank you. So the government has failed to demonstrate why this publicly available information exception is worded as necessary or proportionate, nor what risks it's meant to mitigate in the first place. The CSE has identified a need to access reports on the global infrastructure as a justification for this provision, yet a more narrowly defined list of information types would easily respond to such a need. While Section 7 specifies that privacy must be considered, the nature of the protection is vague, the regulations setting out the scope of protection are likely to be secret, and the potential for invasive information collection and abuse is high. In the CSIS Act, the parallel term, publicly available dataset, remains undefined, but appears to replicate the same types of problems. Finally, we welcome the new accountability mechanisms in C59 and strongly support the creation of the new integrated review body and the introduction of an intelligence commissioner with the ability to exercise quasi-judicial oversight. However, we are concerned that significant gaps remain. The commissioner only issues reasons when rejecting an authorization. The reasons are kept secret from the public. There is no adversarial input. The authorizations will continue to be issued on a class basis, and there is no framework for appeal or review of decisions except by the minister and intelligence agencies themselves. Without amendments that strengthen the role of the commissioner, their ability to exercise meaningful oversight and control will be limited in practice. We welcome questions from the committee about these issues and other aspects of Bill C-59.
Thank you very much. And the first question is Mr. Fragiskatos. And I just think the issue is kind of joined here with this panel, and so if there is a will on the part of one of the other persons wishing to respond, you might get the attention of the questioner or of myself so that they can engage.
Thank you, Chair, and thank you to all of you for being here today. My first question goes to Mr. Leuprecht and Ms. McNorton. In a recent Toronto Star piece, you noted that the National Security and Intelligence Committee of Parliamentarians lacked among the members that have been appointed, lacked a security background. There are some members that have some experience in the realm of security, but by and large, you said that there was a lack of experience and expertise. But I think you would agree that there is something to be said about an outsider's perspective, on the condition, of course, that there is advisory opportunity and to be in the form of a secretariat to assist in the work and provide information and that kind of expertise and background. You would agree that that's a necessary thing.
Look, I think one of the strengths of parliamentarians is that they're generalists and that they have to deal with wide ranges of legislation, but my concern is that there is a lot of dis and misinformation in this particular realm, and it can be very difficult to understand because most people have not worked in the actual community and don't understand. So,
point taken. I just wanted to offer that idea because I think, well, we're on the same page. There is something to be said about an outsider's perspective. Staying with the Committee of Parliamentarians, you have argued and others have argued, for example, Professor Wesley Wark, who we heard from just the other day, that this committee will need a research and advisory support in the form of an independent secretariat. But the question is, where should the experts be drawn from? For example, Wesley Wark says the following, and I'll just quote him for you. Are they too close to the security and intelligence community? Are they going to be too palsy? Too much a defender of the security and intelligence community? Is that a concern that you have? Is that go into that if you could, because I think it's an interesting point.
Look, there's always trade-offs, but I think the expertise is critical for the committee to ask the right questions and to be able to know what information to ask for from the community. And I would also submit that, I mean, what we propose is people, for instance, who are done with their career, who have retired, so they have nothing at stake per se in the overall undertaking. But these are folks who have decades of careers as professionals. So, and I think there are, this is among, if there is a community in the country that takes both their job and the need to absolutely respect the law 100% every time, absolutely serious, it is the security and intelligence community, federally, provincially, and locally in this country.
You don't see a danger in the same way that Professor Wark does, then, that there perhaps would be too much of a close relationship? As he says, are they too close to the security and intelligence community to offer the kind of independent advice and analysis that would be necessary for the parliamentarians to carry out their work.
So there is a precedent set with some of the existing intelligence accountability bodies that do hire employees who have experience with the intelligence and security agencies in Canada, and then they, as far as I know, have not had a problem with it. Additionally, there are also tests that can be employed to test the loyalty of employees.
Okay. Would the Civil Liberties Association have a view on that?
Sorry, I don't think we have a comment.
Okay. Again, to Professor Leuprecht and Ms. McNorton, you point out that there's a fear, or you have a fear of overlap of work between the Committee of Parliamentarians and the NSIRA. Could you go into that in greater detail?
So considering the broad mandates of both NSIRA and NISCOP, there is a potential for overlap, especially in what they review for. So they both could technically review issues related to efficacy, issues related to compliance, issues related to innovation of the agencies. They're geared toward different things. So for example, the parliamentarians has the diversity of expertise, so they would be very useful in reviewing legislation. NSIRA is made up, according to Bill C-59, of former CIRC members, so they have the experience in accountability, intelligence accountability, to look at things more geared to compliance. However, there probably will need to be some kind of delegating of responsibilities to prevent overlap and the minimization of duplication of work.
We also want to consider that every time one of these committees makes a request to the agencies, given that there's no new money to the agencies to support all these new requests, this is effectively a cut in the budgets to the agencies themselves. And so if we want to make sure that committees coordinate so that we also afford the agencies as efficient an opportunity to respond, rather than having to provide very similar things to multiple committees. And I think the greatest payoff for the taxpayer and for parliamentarians and Canadians will be a clear division of labor among these entities based on particular areas of expertise that they bring to bear. And for example, for NISCOP, the one clear advantage is now we finally have somebody who can advocate for changes in legislation, because we know there are many pieces of flawed legislation. This government is addressing several of them in this parliamentary period, and we finally now have, but they're never high enough when cabinet meets to actually make it on the cabinet agenda. And so for years we have had MCs to make changes that don't actually ever make it through cabinet. Now we actually have advocates, we have legislators, parliamentarians who can bring and make sure that the legislation is as effective as possible, both on the constitutionality, legality side, and relative to a changing security environment.
No, it's certainly a welcome development and an important one. You have argued, Professor Leuprecht, in the past that to meet the security challenges that Canada faces, that we would, quote, need to improve professional skills development mechanisms to build the skill sets and recruit the skill sets into our national security organizations. So there's a lot about skill sets there. Are we doing that well enough, in your view, currently?
There are agencies that do it better and agencies that could benefit from some improvement. I think we have a very careful selection process and professional development process, for instance, among the Canadian Armed Forces, within the communication security establishment, to a large degree also within CSE, but we also know that on the law enforcement side, there is considerable opportunity for improvement on capabilities, capacities, and skill sets. And so while I, for instance, respect the suggestions that CSIS should stick to its knitting and as far as possible basically have other agencies deal with particular issues, I would submit to you, yes, in the best of all worlds, we would want to have the RCMP do things like disruption or whatnot. But my submission to you is the RCMP is struggling on so many fronts already that I think we need to figure out also where the relative advantage of different organizations lies and allow them to get up to speed.
Thank you very much.
Mr. Motts, please, 7 minutes.
Thank you, Mr. Chair, and thank you both groups for being here today. Mr. Luprecht, you had said in previous testimony on Bill C-51 that CSIS is the most reviewed intelligence security service in the Western world, and therefore I think we can safely say in the world as it is. In your reading of C-59, are there new layers or any new layers of review placed upon CSIS, and do you think those are helpful in helping CSIS fulfill its mandate?
So, under the new legislation, the NCRA has a wider remit when it comes to reviewing Canadian intelligence and security agencies in general. So they do have the potential under different mandates to not only review for more, but also help CSIS innovate in different ways. So yes, they are reviewed to a more extent. Sorry, I didn't catch the latter part of your question.
And do you think that those are helpful in CSIS fulfilling its mandate?
Yeah, I definitely think that NCRA has a greater potential to enhance the compliance, the efficacy, and the innovation within CSIS.
Okay, thank you. Mr. Luprecht, you also indicated, I guess the powers in C-51 provided CSIS with, they're not uncommon. So you had said in your testimony again on C-51 that Canadians have a profound misconception of what disruption constitutes. And CSIS being able to talk to parents to tell them that their child is up to no good is a disruption power. So, and I can go on with that, but with the changes proposed in C-59, particularly to securing a warrant to conduct certain disruption activities, do you believe we are heading in the right direction with this legislation on that particular front?
I think the challenge is always in, as I think also my colleagues pointed out, in reassuring Canadians that the activity in which the service engages is compliant with the Constitution and the rule of law. And I think there is, while I am personally satisfied that the service engages with the utmost professionalism when it comes to the use of its disruption powers, I think such a measure may be justified in some cases as a way to reassure Canadians that the expanded powers that CSIS has been given, and where there was controversy of whether these powers should reside with CSIS or with law enforcement, and I explained why I think, for better or for worse, they, for the time being, need to reside with CSIS, why why the warrant measures may be necessary to ensure the legitimacy and credibility of the activities in which CSIS engages.
All right.
May I have an opportunity to answer that
question?
Oh, please. We do feel that the scheme that's laid out in C-59, as we said, is an improvement in terms of clarifying what the contours of threat disruption look like, and making clear to both the public and to the service itself what what the acceptable bounds are and what the prohibited bounds are. In particular, the addition of prohibited activities, including detention, was in our view quite an important one. And I do want to just reference that when we express concerns about disruption and concerns about why it is that this is not being done by law enforcement, some of that has to do with making sure that we can effectively prosecute people once we determine that they've done something contrary to the law. The other thing is that we've never been particularly concerned about the kind of disruption that you mentioned. So talking to a parent and saying your child's been getting into some trouble. We're more concerned with some of the items that are now specifically enumerated in the legislation, things like fabricating or disseminating any information, record, or document, altering or removing websites and communications, things like that. So it's helpful in our view to have that in the legislation, and we do have suggestions for how the warrant scheme might be improved, and we can elaborate on those more in our written submissions.
Thank you. Mr. Luprecht, from your background in history and working in cybersecurity, are there steps that we need to be taken to protect our critical infrastructure? And does restricting CSEC to reacting to significant and widespread threats help Canada or delay our ability to respond?
So look, I think the government's proposed establishment of an act for CSE itself is a huge improvement in innovation over the current situation where it is embedded in the National Defense Act. I would say that on cybersecurity in this country, by and large, not only do we have our head in the sand, we need to do much better at especially the intelligence sharing. So the CCTX, the new mechanism to exchange cyber intelligence, is, I think, a good improvement here. One of the challenges that we have had is that CSE is by law extremely restricted as to what it can share and under what conditions it can share with the private sector. And in this area, you ultimately need to prevent and anticipate, and effective and timely intelligence sharing, given how quickly cyber challenges and threats move, are integral. Other countries are much further ahead. If you look at Australia, the Netherlands, Israel, the United Kingdom, this is what's sometimes known as phase 2. If we cannot effectively protect our cyber infrastructure, that is going to have a deleterious consequence for our economy, because people will only invest in innovation, in R&D, in the Canadian economy, if those elements are then also protected, because why would you invest if that's going to be immediately stolen? And so I think for the sake, and we know that this country has done particularly poorly on the innovation agenda, and luckily this government is trying to improve Canada's innovation capacity, that will not be effective if we can't then also ensure that the cyber domain is effectively protected.
Sorry, Mr. Chair, may I have an opportunity to respond to that question as well?
I have 30 seconds. I have one more question I do want to respond to, sorry. Bill C-59, as we've heard from the Justice Department, will make it more difficult for law enforcement to secure preventative arrests. Now, because of the threshold is being raised to secure such an order, do you, Mr. Lubrecht, consider this to be problematic?
Answer to that question, because we've just run out of time.
Can you provide that to us, to the committee in writing, if you could, to that question?
Okay.
Thank you, sir.
Thank you. Mr. Dubé, 7 minutes, please. Sorry.
Thank you, Chair. I don't know if you wanted to answer that question, because I'm coming to the cybersecurity stuff as well.
I would love to. Thank you for the opportunity. The question was about how Canada's cybersecurity can be improved, and I would like to draw the committee's attention to the active and defensive cyber operations aspects of CSE's mandate that have been added in sections 20 and 19, respectively. It's our position that the inclusion of these two aspects and the activities that come along with it may actually run counter to Canada's broader security interests. And I would draw the committee's attention to, in particular, the short list of prohibited conduct in Section 33. And I think there are at least three fundamental problems with that section. The first issue is that for reasons which are not clear to us, the explicit limitations for prohibited conduct only apply to authorizations issued under the defensive and active cyber operations component of the mandate and not the rest of CSE's activities. The second issue is that neither justice nor democracy are defined in the Act, leaving the limitation about interfering with the course of justice and democracy vague and open to perhaps creative interpretation. The third problem is that this short list of prohibited conduct from our perspective is radically under-inclusive, and at minimum the committee should compare the list with that in the CSIS Act in 21.1 with that in 33.1. And so we are concerned about the broad scope of potential activities that CSE would be able to conduct under these aspects of the mandate, and we're not convinced that they've been appropriately justified.
Thank you for that. I want to stay in Part 3 of the bill actually as well and look at specifically Section 24. And I'm open to hear from everyone, but in particular from you, Ms. Gill. You mentioned encryption software, so some of the applications that are used and often not just used by so-called bad guys, but also by people, Canadians, law-abiding Canadians seeking to protect their privacy. In the course of, in particular, B and C, where we're talking about essentially testing and studying information infrastructure and evaluating software and testing them for vulnerabilities, does that potentially create a situation where we can go down that rabbit hole and find ways to counter some encryption that can be used for lawful purposes of simply having the peace of mind of protecting your privacy?
For that question, certainly we know that allied intelligence agencies have engaged in the past in activities meant to interfere or undermine encryption and anonymity tools. And I think that we should be concerned about those types of operations, not just in the course of the testing and infrastructure information aspects under 24, but more generally in the pursuit of the foreign intelligence mandate. Encryption and anonymity tools are vital to protecting the safety of Canadians and persons in Canada, as well as Canadian infrastructure. And so we should be concerned if the CSE ends up, inadvertently working at cross purposes by interfering with the very tools designed to protect us. I would also raise, and this is something that's been raised in the past, is that there's no public framework for disclosing vulnerabilities, and that is an issue that while CCLA doesn't have a concrete position on yet, it is an open issue from our perspective.
And when you say disclosing vulnerabilities, you mean CSE disclosing those to, say, the private sector, so for example, a telecom company?
Right, yeah, responsible disclosure to ensure that where CSE finds vulnerabilities and where it's appropriate and, in the public interest to do so, that they are disclosed responsibly in order to protect privacy interests, and as well as expression interests. This is not just about privacy rights. Of course, these types of technologies, our digital ecosystem is an important guarantor of the right to freedom of expression protected under Section 2B of the Charter, as well as broader interests of security and liberty that I think, all Canadians in this committee is very concerned about.
I also just wanted to look at 24.4 as well, information acquired incidentally. I don't know if you had any thoughts on that, where it says the establishment may acquire information relating to a Canadian or a person in Canada incidentally in the course of carrying out activities under an authorization issued under, and then listing the appropriate subsections. Especially in the context of information sharing, is there any concern with that type of provision?
Yeah, that's something that we hope to detail in our written submission more explicitly. We are concerned about that. The words incidentally are defined, but the limitation of not directing is not defined anywhere in the Act, and that's a concern that experts, including Bill Robinson, has raised in the past, which would help better define the contours of what we mean. And certainly to the extent that CSE engages in unselected bulk collection, there will be incidental collection of Canadian data, and we do have to make sure that measures, explicit, clear, and detailed measures are taken to ensure that that information is handled responsibly where collected.
Okay, and my last question on part 3 would be concerning the number. There's many sections dealing with authorizations, ministerial authorizations. I don't know if there's any thoughts on that. In particular, one aspect is the extension of the period of validity, without being subject to review by the commissioner that's being created by this very same bill.
Yeah, we are concerned about the ability to extend by the 1-year period, but we do think that it's important that where there's a significant change in the scope of the authorization, that's brought to the commissioner's attention, so we think that's important. We would want to also raise that the authorization framework for active and defensive cyber operations is extremely problematic from our view, insofar as those operations have the capacity to significantly interfere with expressive privacy, security interests of Canadians and persons in Canada and persons elsewhere. We don't believe that ministerial authorization through the Minister and the Minister of Foreign Affairs is sufficient, and we would prefer to analogize these types of powers to the disruption powers or the threat reduction powers in the CSIS Act, and note that there is a much more rigorous system for oversight and prior authorization in that context. I would also note that if the committee decided not to adopt these aspects of the CSE Act, which allow CSE to engage in active and defensive cyber operations unbound from other aspects of its mandate, CSE could continue to assist CSIS through its assistance mandate in the course of threat reduction activities. Thank you.
So judicial oversight, essentially.
That'll be detailed in our written submissions. Okay. For now, what I feel comfortable putting on the record is that we're not comfortable with ministerial authorization alone.
Thank you.
Thank you.
Ms. Damoff, 7 minutes.
Thank you, Chair. And just before I start, I actually have a student shadowing me today, and I just wanted to recognize Ian Lewis, who is here. He's a student here in Ottawa, and I think it's wonderful that he's taken an interest in what the national security framework in this legislation is looking at. So During our previous study, the National Security Framework, there was a lot of desire on the part of Canadians for greater transparency from the intelligence and security agencies. We also heard that when we were looking at Bill C-22. A witness we heard from at the last meeting, Dr. Stephanie Carvin, was actually quite passionate about calling for better transparency, and she actually cited a couple of models to look at. One was the U.S. Office of the Director of National Intelligence Worldwide Threat Assessment Report, as well as the recent report on cyber threats to Canada's election system and democratic institutions by the Communications Security Establishment. And I'm just wondering if perhaps both of you could comment on that, and if you see that as being something that should be included in the legislation that we're looking at, or if it's something that would be looked at more through regulation or through ministerial directive.
That the NCR provides a greater transparency because they have several different types of reports, including annual reports and agency-specific reports that they must submit to Parliament.
Back off the microphone just slightly, please. Thank you.
So they have a number of reports that are going to Parliament, which parliamentarians, as public representatives of the people, can read and analyze and speak about. I think that really will speak a lot to enhancing transparency. I know that the agencies themselves, specifically CSE, and the existing accountability bodies have made a kind of publicity push to get people knowing what they do and how they do it, and kind of giving them more information regarding that.
So just before we move on, when she was here, she was talking specifically about the U.S. report where it deals with specific threats. So it outlines the number of threats, and so it was very specific on threats within the United States, which is a little different than I think the reports that we'll be getting to Parliament right now.
I think there is a need for demystification because, of course, our adversaries play actively in this environment on a permanent basis. Cyber is the single greatest threat to our national security, to our democracy, our social harmony, and our prosperity today. And so I think there is opportunity here to be more systematic in how we communicate that to Canadians, but also where we currently don't do particularly well is small and medium-sized enterprise. Large enterprise has the capacity. Small and medium-sized enterprise, the people who generate much of our prosperity, our innovation, and much of the employment in this country, currently do not have access to those tools. And I think any mechanism that the government can agree upon to inform people better and give, for instance, organizations such as CSE more capacity to support small and medium-sized enterprise would be critical.
Okay,
and I think a report is one effort to that effect.
And did you have any comment on that? Thank you.
Yes, thank you. I mean, I think that in general, the CCLA would share Professor Carvin's passion for the concept of transparency. In relation to the U.S. report on specific threats, one of the things we often hear as a civil liberties organization when we make comments that are perceived to be idealistic about national security and accountability is that we don't understand what's really going on. A report such as you're referring to, which actually shares with all Canadians the nature of real and existing threats, would provide, I think, an important framework for every Canadian and every civil society group to be able to make more rational assessments in relation to these kinds of analyses and processes that we're going through today, and enhance public trust that, that things are happening as they should, that risks are real, and that we therefore have the clear and specific procedures enacted in legislation to deal with the kinds of threats that we're legitimately facing.
Thank you very much. The next question I had to ask has to do with the minister's testimony when he was here before this committee on Bill C-59. And when he was talking about the changes from Bill C-51, amending, advocating and promoting the commission of terrorism offenses in general, and adding replacing the offense to apply only where a person specifically counsels another person to commit a terrorism offense, and it provides a clearer and more appropriate legal structure surrounding them. So when he was questioned, he was asked if this would provide law enforcement with actually better tools to be able to enforce. Now, you had mentioned something about you thought that the definition was still too broad. So I guess my first question is, I don't know if you had an opportunity to see what the minister was saying in terms of it actually narrowing the definition to allow law enforcement to enforce. But then I'd also welcome comments from both of you on that.
I didn't have the opportunity to see all of the minister's testimony, but I do know that, and we do agree that this is an improvement in terms of narrowing the offense considerably. In our view, it's still arguably unnecessary, since counseling any offense that's already an offense under the criminal code is already an offense. And so it's not exactly clear what this offense is doing. The fact that it references terrorism offenses, which is not actually a defined term in the code, makes me think that there may be some interest in being able to prosecute someone for counseling without having to specify which terrorism offense in particular they were counseling, which is potentially problematic from a rule of law perspective in terms of someone understanding what it is they're charged with and where the bounds of the law are. But the list of terrorist activity in the code, and that's the language we think should be inserted into that provision, is quite a long list, and it does include a number of things that fall, well beyond any acts of violence, things that are participating, that may be facilitating terrorist activity, and so, we think it could be sharpened and clarified by making that amendment.
Thank you very much. Ms. Leach, we're down to about 3 minutes.
Thank you very much, Mr. Chairman, and thank you all for taking the time to come today. Mr. Leiprecht, I'd like to ask you one particular question. I guess in follow-up to your comment about how Canada no longer lives in an isolated part of the world with respect to these issues around security. Bill C-59, we've heard from the Justice Department, will make it more difficult for law enforcement to secure preventative arrests. Because the threshold is being raised to secure such an order. I was wondering if you could make some comments with respect to that and your perspective on it.
The challenge in that space is that you ultimately have to be preventative, and different countries have different mechanisms. The Australian Criminal Intelligence Commission has fantastic mechanisms that work very well in this particular sphere. So I'm concerned about the reduction of the ability to work in a preventative space. I'm also, and this ties in with the previous question, deeply concerned that we have upwards of 120 Canadians who have returned to this country, some of whom have pillaged, raped, killed, and are able to return to this country and live here with impunity because we do not have the legislative instruments to bring them to justice. And to that effect, it's helpful to have some changes with the criminal code, but we need other offenses, including offenses, for instance, that make it illegal to travel to certain parts of the world, which has proven a very effective measure in Australia to prosecute people who engage in this type of activity. So, yeah, I think we're tinkering at the edges here when it comes to preventive arrest and when it comes to how exactly we define it to hopefully make it more effective for law enforcement to use the tools that we have, but I think there's a lot more that needs to be done.
Now, maybe I could ask all of you another question. In your reading of Bill C-59, each of you have made some comments with regards to the number of layers and whether or not there will be new reviews placed on CSIS and their capacity to be able to do things. Do you think that it's helpful in allowing CSIS to meet its mandate and having these additional layers? You had commented, Mr. Leiprecht, with regards to the issues around methodology and how that would be implemented. Could you make a comment and then we'll come back to the others?
I think that in order to allow CSIS to complete their mandate while making the most of their resources and time, that the Committee of Parliamentarians and the review agency should coordinate on how they get information from CSIS, whether it's through their parliamentary liaison, just to save time and not so much burden on the agencies.
And there is a cost to every layer of review and oversight that we impose on agencies. And without additional funding, in a democracy, we need to weigh the trade-offs in which we engage, but there are, as we have mentioned, potentially quite positive outcomes, especially in terms of efficacy and innovation for the community itself as a result of the work that will be done.
Thank you, Ms. Leach. And on behalf of the committee, I want to thank all of you for your contributions, and we look forward to receipt of your further submissions as may be required. With that, we'll adjourn. Thank you very much.